Today on KPFT's Open Journal, an exclusive interview with Ian Wingfield, former Solicitor General of the Legal Policy Division of the Department of Justice for Hong Kong, and an eyewitness to the intricate legal dances that made the handover or the return of Hong Kong from British rule to the People's Republic of China happen. I'm your host, Marlo Blue. And now, my interview with Ian Wingfield.
Thank you very much, Marlo. Good to be on KPFT.
Thank you so much for joining us, Mr. Wingfield. Now, first, a little background, if you don't mind. Hong Kong's territory was acquired by the United Kingdom from 3 separate treaties in the 1800s, giving them control of Hong Kong Island, Kowloon, and the new territories. Although Hong Kong Island and Kowloon had been ceded to the UK in perpetuity, the control of the new territories was only a 99-year lease set to expire in 1997. Is that all right?
That's correct,
so far?
Yes. It was the 19th century, 1841, when the British first acquired Hong Kong Island.
Now, it was because of the economic success of Hong Kong Island spilling over into the new territories that this story really becomes so interesting. Most point to Governor Murray Maclehose's visit to the People's Republic of China in 1979 that brought the question of Hong Kong's sovereignty to light. But tell us your story. You were first appointed to the Attorney General's chambers of the Hong Kong government as a Crown Counsel in 1982. Tell us about those early days.
Just to pick up a little bit on the question of the visit of Murray Maclehose, the reason that it became important to resolve the question of Hong Kong was that the new territory leases, which had been granted by the government to land owners in the new territories, were all set to expire in 1997. And so it became important to resolve what would happen to those pieces of land that had been sold by the government to private landowners when the treaties came to a conclusion. My first role in the department, I came out as a government lawyer from the British government. I'd been a government lawyer in Britain for 6 years, and I was originally posted out on secondment from my home department, which was the Lord Chancellor's department. And I initially started off doing very mundane cases, civil litigation, tax collection work. I was particularly interested in anything relating to social welfare because that was what I'd been doing in the UK. So I went to court and did cases involving the adoption of children and court guardianship for children who had been abandoned. And so that was my initial job. It was fairly low-level work for the government, but already very interesting and quite varied. And then as I moved up the department, I was promoted very speedily after my arrival in Hong Kong. My work became more concentrated and became more concerned with administrative law questions, particularly relating to the status of immigrants and illegal immigrants and refugees. So that was my second area of increasing responsibility. Administrative law questions became more important as the status of Hong Kong became resolved, because 2 years after I went to Hong Kong, the Sino-British Joint Declaration was signed, and from that time the sovereignty of Hong Kong was going to be ceded by or returned from the British government to China on the 1st of July 1997, and everything then, the emphasis of the legal work was directed towards ensuring a smooth transition in that period.
This was all under British law then?
Yes, the Joint Declaration is subsequently became the basis for the Chinese Basic Law. The Basic Law of Hong Kong is a Chinese law enacted by the National People's Congress, and it applies to the relationship between Hong Kong and the rest of the mainland, but also preserves the rights and freedoms of the Hong Kong people as they were under British law before 1997. So one of the provisions of the Basic Law is that the law of Hong Kong will continue to be the British common law, the statutes enacted before 1997, and laws enacted by the legislature after that date. So the basic provisions of law and the legal system were very much those of the previous system and were based on British or English law, to be more precise, because Scotland has a different legal system.
Well, and I want to ask you a little bit more about that in detail a little later on. Let's go back again to the handover, to the change, as it were. Can you actually tell us about the day? Were things ready? Were the people ready? Was there ever a point when you thought it wouldn't happen?
There were a number of issues that were identified fairly early on as being of crucial importance. One was to make the laws accessible to the people of Hong Kong. Although both then and now the language of the law is English in many respects, it became important for statute law to be translated into the language of the people of Hong Kong, the majority of whom don't read or speak English, and therefore it was necessary to translate all the statute law into Chinese. So from 1984 through to 1997, there was a huge program of translation. There was also a lot of British legislation that had been applied directly to Hong Kong by either the British Parliament when it enacted the laws, or by the British government by order in council. So it was necessary again to what we called localise those laws, so that that part of the legal system continued through locally enacted legislation. So translation and localization of laws were two of the major issues. It was also necessary to ensure that the continuity of the civil service was ensured. One of the provisions of the Basic Law was that civil servants who had previously been employed by the British government in Hong Kong, in the Hong Kong government, could continue to work after that date. In the period between 1984, when the Joint Declaration was made, and 1997, there was a great deal of uncertainty as to whether British civil servants would continue to be welcome in Hong Kong. And I have to admit, I did make one or two inquiries about possible alternative employment round about 1990 and thereabouts. But as we got closer to 1997, it became more and more apparent that not only would the Chinese accept the continuation and employment of senior British civil servants in the civil service, but they would positively welcome it. And it was made quite clear to me that if I wished to stay on after 1997, I would be permitted to do so, and that the incoming sovereign would be very pleased if significant numbers of lawyers and judges would continue to be employed.
Well, now, of course, Hong Kong and Macau have separate legal systems from the PRC, so tell us about one country, two systems as cohesively as you can, and why the separation is guaranteed constitutionally until at least 2047. How did 2047 come up?
Well, 2047 is what's stated in the Basic Law and in the Joint Declaration as being the period during which capitalism would continue in Hong Kong. That's the only reference to 2047. It's a 50-year period during which the communist system will not be introduced into Hong Kong. But I think what's been widely misunderstood is that the other aspects of the Basic Law are not in any way time limited. And the Chinese government has made it quite clear that as far as it's concerned, the Basic Law is a continuing law that, until modified or repealed, will continue to apply to both Hong Kong and to the relationship of Hong Kong to the rest of China. So 2047 isn't another date before which everything has to be changed. Leases of land are given way beyond 2047, for example. So there's no inhibition on the time within which a land lease has to be terminated. I think that aspect of the Basic Law is, although misunderstood, it is, I think, fairly clear that there is no there isn't a period of time within which things have to be resolved again. The whole essence of the Basic Law is continuity, so that the legal system as it was known before 1997 it's provided that it should continue. And so that is the real basis of the concept of one country, two systems. It's not just two legal systems in a narrow sense of the laws, but also the institutions, because the Basic Law provides that the power to legislate for Hong Kong shall be vested in the Legislative Council of Hong Kong. There is a overriding power to legislate for Hong Kong by the Central People's Government, provided for in the Basic Law. And those things are actually specified in an annex to the Basic Law. The provisions which may be covered by direct legislation are themselves limited to defence and foreign affairs, so that only questions relating to sovereignty, things like the national flag, the national anthem, the territory of China and of Hong Kong are covered by the statutes. Chinese nationality is also another provision that is covered by national laws, because obviously those reflect the fact that China is the sovereign of Hong Kong. But as far as legislation covering every other aspect of law in Hong Kong, it's enacted either previously and carried over through the reunification, or it's enacted subsequently by the legislature of Hong Kong. The other aspect of separation is an independent and separate judicial system. Mm-hmm. So these are really the three key components: separate law, separate legislative power, separate judiciary. And while before 1997 the highest court for Hong Kong was the Privy Council in London, the court now that finally determines all cases is the Court of Final Appeal in Hong Kong.
We'll be right back with more of our interview with Ian Wingfield in just a moment. But right now, a few words by the Open Journal staff.